Kat to take a roll call.
Shear.
Here.
Olson.
Here.
Berardi.
Here.
Smith.
Here.
Zeiland.
Present.
Arthur.
Here.
And Mr. Frankel is absent this evening.
I understand that. First item on the business would be a report on the council activities. Councilor Kohlhoff, could you have the floor?
So we're back in business full time. We had a first meeting right off the bat, was a Measure 49 claim. And the basis for that was the flag lots. The claimant had wanted to put in another house for himself and would have been precluded from doing so and put in this Measure 49. That was a 6-1 to waive the requirements or waive, how should I say this? It was to waive the statute so that they would be able to proceed as if that flag lot ordinance hadn't been in place. There was another ordinance that got passed about temporary enclosures, specifically for restaurants. I think that the general motivation for that was to, prime the pump economically. And that one passed. I think that was a 6-1 as well. We signed the initial agreement regarding the design on the 2 pools. Sometimes we say there's going to be a pool. There actually are going to be 2 pools. One, a warm water pool for people like myself who splash around and maybe can swim with the masters. And then the competitive pool for the high schoolers who would have a much colder pool. Anyway, that is now in the works. And the historic resource statutes I say statutes, that just forgive me for that. That's the lawyer coming out of me, but the ordinance there had been a move to have the HRAB people be able to be the adjudicators on things that were specifically within their purview. But again, a majority said that you should have that job. So that's where that sits. Then finally, last night, something that I'm assuming was near and dear to your heart, because I have 1,000 pages that I went through, and that was your Meadows case. And you're well aware that there were the 2 issues that came out of the appeal, which was the trees, the 112 trees, and the traffic. So the long and the short of that is that you send it back so we had an initial vote last night, and then it goes back to having the city attorney prepare the findings and so forth for a final vote. And I think that's in October, the first meeting in October. And that, so you don't know how that's going to be, but generally speaking, the final vote is similar to the first vote, and the first vote last night was 5-2. Actually, as Councilor Lamont and we may be contenders in other ways, but we both would have allowed the appeal. But it was 5-2 the other way. But like I say, I know you worked really hard, because I have to have printed out, because I just can't get it together with a record that big electronically. And so that was quite extensive. But it was well done. I mean, the meeting was very well done and very easy to follow the arguments, and easy to visualize what they were getting at. So in that regard, I have nothing but admiration for staff and the lawyer for the developer. All of them did a good job, but I know you guys worked really hard. They're a hardworking group.
Thank you.
That's it. Unless you have questions.
I have two. The
Good.
site of the pool, is it still at the par 3?
Yeah. Yeah. That, it just, there were too many other demands for the other pieces of property. That wasn't my favorite. I still think there's going to be kickback over that, but there could be good things that come out of that. In other words, the golf course, by being reconfigured, might actually be very attractive. Who knows? But that's where it's and a rec center.
Okay. And then you referenced on the Meadows project 5-2. I'm assuming the 5 voted to allow the project to go ahead.
Yeah.
Okay.
Yeah. John Lamont would have sent it back on a remand to you and tried to save some trees. That didn't appear to be something that was going to happen. And so given the way the motion was set up, he voted no, which the way the motion is written, it was weird, but basically it was that we would not go for the appeal. And I'm just thinking that the tree code as a code is a nullity. And that's where I come out. So the 112 trees definitely were not going to be okay with me.
Any other questions? Councilor, thank you very much.
You bet.
Appreciate it.
Bye-bye.
Now we have the minutes from the July 20th meeting. Has everybody had a chance to review them? And if so, are there any changes? If not, I would ask for a motion. Okay. Kirk, would you like to enter a motion?
Reading his lips, I think he made the motion.
Oops. I move that the minutes of July 2020 be approved as submitted by staff.
Second.
Thank you, gentlemen. I appreciate it very much.
You're very welcome.
Kat, can you take a vote?
Here,
Yes.
Fulton,
Yes.
Already,
Yes.
Smith,
Yes.
Zeiland,
Yes.
Arthur.
Yes.
Just a point of clarification before we continue. Tonight, we are just going to hear LU 190049 as the type 2 tree permit on the agenda has been removed. So just a little bit of housekeeping.
Ms. Chair Scheer, just to clarify in case anybody has tuned in for that, it's been canceled because the applicant has withdrawn the application. So the application is completely withdrawn. So I just want to make that clear to anyone who might have tuned in for that particular application.
Thank you. I appreciate that. Okay, so now we'll go to the public hearing on LU 19-0049, a request for a development review permit for a structure accessory to an existing car wash located at the Lake Grove Village Center, in the Lake Grove Village Center overlay. The site is located at 16110 Boones Ferry Road, 21E08CB04200. The staff coordinator is Ellen Davis, associate planner. Evan?
Thank you, Mr. Chair. I'll read the process and modified for our virtual hearing. This land use request is considered based upon the applicable criteria and standards. The staff report lists the criteria and that staff identified which are applicable to the request. It was available and is available online. Is available. Forget that. You must identify any applicable criteria you believe applies. Testimony and evidence must be directed towards the applicable criteria. Please specifically identify to the commission the criteria or standards you are addressing, so the commission may consider your testimony in relation to the criteria or standards that you are addressing. If you do not identify the criteria or standards, the commission is not obliged to guess which standards or criteria you are testifying about and may not consider your testimony in its decision. Failure to raise an issue accompanied by statements or evidence sufficient to afford the commission and the parties an opportunity to respond to the issue precludes appeal to the City Council and the Oregon Land Use Board of Appeals based on that issue. The failure of the applicant to raise constitutional or other issues relating to any proposed conditions of approval, if approved, with specificity to allow the commission to respond to the issue precludes action for damages in circuit court. Now, the public hearing process is as follows. First, there'll be a presentation by staff, then testimony by the applicant up to 20 minutes, then testimony by parties in support of the application, followed by testimony by parties opposed to the application, and finally testimony by those neither for nor against the application. Individuals will be allowed up to 5 minutes. Any person in attendance may cede his or her time for testimony to another person except to the applicant, but in no case shall any person's testimony be increased to greater than 10 minutes. Recognized neighborhood associations, homeowner associations, government or government agencies, or other incorporated public interest organizations will be allowed up to 10 minutes. Following that would be the applicant's rebuttal up to 5 minutes, and then commission deliberation. And then a statement by the applicant to the commission of any proposed conditions of approval different than contained in the staff report, again, if the commission approves, and the applicant's response to the commission's conditions of approval proposed following commission deliberation. Now, following the testimony by all interested persons that have signed up to speak and the applicant's rebuttal, I will ask whether any person requests a continuance of the hearing in order to submit any additional evidence or testimony. You may request a continuance by, if you are on Zoom and you have testified or testifying, either at the end of your testimony or at the conclusion of all testimony, I will ask if anybody requests a continuance, and at that point, unmute and request a continuance. If you're not on Zoom because you're watching on YouTube, call Kat Klug, K-L-U-G, at 503-635-0286 and leave your name and contact information with her. Or 3, you can email her at kkluge@lakeoswego.city with your name and contact information prior to the close of the time. We generally give about 3 minutes for people to call in and request that continuance at the close of the testimony. The time limits do not include time spent responding to questions from the commission, testimony by attorneys, representatives, and witnesses on behalf of or which are part of the presentation by a person shall be counted within that person's time limit. It is assumed the persons are testifying on their own behalf unless they expressly identify the recognized neighborhood association, homeowner association, government or government agency, or other incorporated public interest organization they are representing. Now, a potential conflict of interest is declared on behalf of each of the DRC members to the extent of their business or employment, which each will identify. Unless declared otherwise, the respective DRC member does not have a known present or anticipated future business relationship with the project or the applicant. It is possible that a future business relationship could arise in the initiation, design, construction, or maintenance of the project through either the employment or business of the DRC member personally or through a relative as defined in ORS 244-020. At this point, I would ask the commission members to please declare if you've had any ex parte contacts, including a site visit, if you're biased on the application, if you have any financial conflicts of interest, and your state your business or employment. Mr. Chair, if you'll make that declaration and poll the rest of the commission.
My name is Jeff Shear. I am a retired contractor. I have no bias. I didn't make a site visit just to see this particular structure. I've been in that area for a car wash or drove through there, so I'm very aware. I'm aware of it. I have no business relationships, no ex parte contact, and no financial conflicts. But one of the owners is a fraternity brother of mine from our time at Oregon State, and he's also been a physician for a member of our family. But I don't think that impacts my understanding on this case.
And if you'll poll the rest of the commission members in your whatever order you want.
Okay, Kirk?
My name is Kirk Smith. I'm an attorney with the law firm of Buckhalter Ader Wynn. I'm a real estate land use attorney there. I've run conflicts with the applicant, and based on the information provided me by the city, we have no conflicts with this applicant. I've made no specific visit to the site. However, in my years living in Lake Oswego, I've been there many times for a car wash. However, I did not make a specific visit. So I'm saying I'm familiar with the site, but I didn't go and look at the current structure that we're reviewing. I have no other ex parte contacts, no bias, no additional financial conflicts of interest.
Thank you. Randy?
Good evening. This is Randy Arthur. I'm a civil litigation attorney with the Portland, Oregon office of Bullivan Bailey, PC. I received key names associated with this application and caused a conflicts check to be run in my office. None of our clients nor the firm have a conflict reported with any of the principals or professionals involved with this application. As far as I'm aware, I could find out. I've not made a site visit. I have no disqualifying bias. I have no financial interest in the outcome of this, and feel I could listen fairly to the evidence and make a decision.
Thank you. Mark?
My name is Mark Zeiland. I'm a retired physician and a business owner. I have no ex parte contacts. I have no financial conflict of interest. I don't have any disqualifying issues, other than I will just mention that one of the named owners was a treating physician of mine, underline was, several years ago. And that's all. Thank you.
Thank you. Vice Chairman David.
Yes, my name is David Polson. I'm a civil engineer. I have visited the site many times, but like others, I didn't make a specific site visit for this. I've had no ex parte contact. I have no biases, and I have no financial conflicts of interest.
Thank you. Craig?
Hi, my name is Craig Berardi. I'm a financial consultant. I have not visited the site. I'm familiar with the site, have not been there recently. I have no ex parte contacts, no bias, and no conflicts of interest.
Thank you. Is there from any person who's signed up on Zoom, is there any challenge to a commission's right to consider the application or by the applicant? Hearing none, Associate Planner Ellen Davis with the staff report.
Good evening, Commissioners. I have to apologize that the reason you see me up there twice is that I have my laptop, which does not appear to have the bandwidth right now to show video. Seems like there's another meeting going on tonight. So if that ends before this and frees up some bandwidth, then I'll jump on with video also. But for now, I do have my presentation ready to go. So I will go ahead and share that so that we can all view this presentation, which is fully displaying now. So before us tonight, we have Land Use 190049. And actually, before I jump too far into this, I'm going to read into the record that we have received 4 exhibits since the publication of the staff report. We've received G201, 202, 203, and 204, and all 4 of those exhibits have been emailed to you. So you should have received those already prior to the meeting tonight. A lot of the comments were in support of the design variances and the use, but we're in opposition to we're in support of the site variances, but are in opposition to the design variances that we will dive into in a minute here. So moving on, the location of the site is within the Lake Grove Village Center overlay. There are 2 subject tax lots, but the site does function as one unified site. So we are treating it as a unified site. And if this application does move forward, we do have a condition of approval to formalize that unified site status. Currently, there is a car wash structure on this property as well as a car wash structure over here, and this is the approximate location of the structure we'll be discussing tonight, the accessory structure. The accessory structure is shown here. This was taken at the end of July, so this is roughly how the structure looks today. And there are 6 variances requested with this development review permit for a 12-foot by 16-foot accessory structure for a car wash business that has already been constructed. It is subject to code enforcement at the moment, and that is the purpose of them coming before us tonight. They've requested 6 variances, which we have broken up into site design variances and building design variances for ease of discussion. So the site design variances are the build to line, minimum building width, and minimum height at street frontage, and we'll look at those first. So the site design variances are to the build to line, which says that a new structure would need to be built within 10 feet of the front property line. In this case, the site is already built out and contains access lanes, an existing access, and landscaping within that 10 feet. And it really doesn't make sense to put the accessory structure within 10 feet of the front property line in this case. There's also a requirement of minimum building height and minimum building width at that build to line at that 10 feet. So staff is recommending approval of the site design variances. We do not find that locating the structure within the first 10 feet of the front property line would really make sense for this use in this structure. However, the building design variances to the general architectural style, siding materials, and roof materials, we do not find that the variance narrative provided by the applicant shows compliance with 2 of the criteria. So the first criteria that we find is not met by the materials that have already been submitted is the general design variance criterion A2, that an alternative design will better accomplish the purposes, goals, or objectives of the LGVCO. And then the second standard that we find has not been met by the materials submitted is an analysis of alternative designs. So we do not find that the general architectural style, the siding materials, or the roof materials have been demonstrated to meet the criteria for these 2 variance standards. So we do recommend approval of the site design variances for the location of the structure, but currently we cannot recommend approval of the building design variances. The applicant can present additional testimony and materials at this time, and if the commission does choose to approve all 6 of the design variances based upon that additional testimony or evidence submitted by the applicant, I would like to point out that there is a typo on page 2 of my staff report, which is where you'll find the conditions of approval recommended if you do approve all 6, and that is in condition A1. I would recommend after E004 adding a period and striking out where it says with 1 modification. That is a typo, so that could be removed. If you do want to move forward with just approving the site design variances, but not the building design variances, then we would alter these conditions slightly, and I can talk you through that if you're interested in exploring that option. And then if you do choose to deny the entire application, then because the building is constructed without the required development permit and building permit, then code enforcement actions would continue and would lead to removal of the existing structure. So those are the 3 options that are laid out before you tonight. We do recommend approval of the site design variances because we do find that those criteria are met. But that concludes my short presentation. If you do have any questions, please let me know.
Thank you, Ellen. Do we have any questions for Ellen, gentlemen?
Yes, I have a question. you know, I'd hate to see them rip down the building, but I need a little bit more detail on, you know, what they could do to, you know, repair what's there. And the only thing that I think is the most significant is the architectural style. So could you go into that a little bit more detail of what is deficient in the architectural style itself?
Yes. So there are very specific architectural styles that are allowed in the Lake Grove Village Center overlay. And so the structure would need to comply with one of those architectural styles or be a mixture of those architectural styles. And some of the architectural styles that would be permitted would be Italianate, Chicago School, Cape Cod, and there are just a few other architectural styles. So currently the structure does not appear to reflect any of the architectural styles of the zone. So that would involve major modification of the structure most likely. Also, the siding materials and roofing materials are currently prohibited materials in this zone and aren't necessarily reflective of any of those permitted architectural styles. So there would be fairly substantial changes to the existing structure, most likely, to bring it into compliance with those architectural design styles and to change out the siding and the roofing.
So in other words, if you see what I'm driving at, it's that, let's just say you could, excuse me, replace the siding, replace the roofing, but in order to modify the structure to meet the architectural style, that's more like a, you know, a wholesale change to the building that, you know, it'd be like splitting hairs whether or not you tear down the building and rebuild it again versus just modifying it.
There might be some sort of creative design solution that might not involve tearing down every wall, that could focus more on changing the finishes of the structure, the windows, to try to better reflect one of those styles. But it would, or potentially adding a different roof form that's more reflective of one of the other architectural styles. So I'm not certain the level that would be necessary to change the structure to comply with a different architectural style. It wouldn't necessarily involve tearing down the entire structure, but it would involve pretty substantial modification of the existing structure.
Let me just ask you one other way. Does it meet, as it is now, does it meet the glazing standards or the fenestration standards? In the,
I don't believe that they had a glazing or a fenestration standard. I'll have to look back through my report, but I don't believe that they were non-compliant to those standards if they were applicable.
okay, all right, thank you.
Any other questions? Ellen,
Jeff.
Go ahead.
Yeah, I have a question. Hey, Alan, thanks for that presentation. Do other buildings in the area, because I know that's, you know, pretty old and area and they've been there a while, are they in compliance with that architectural style? Is this gonna put them out or is out of?
No, so that is a good point. The other existing structures on the site are not built to the Lake Grove Village Center overlay standards. They were constructed prior to the adoption of that overlay. I'm going to share my screen again so I can kind of point to what I'm talking about, if I can. Oh, previous. Yes, this is probably the least effective way. Okay, so this structure on the site is not compliant with any of the architectural styles allowed in Lake Grove Village Center overlay, and neither is the structure on the neighboring lot. So they're all flat roofed, have awnings. This structure, I believe, is brick, but not in one of the specific architectural styles allowed by the overlay. So the existing site is not in one of these architectural design standards.
I do want to add, if I may, that there are many buildings within the Lake Grove Village Center overlay that don't meet those standards, and those are allowed to remain for as long as they want to. They're considered to be legally non-conforming. However, the code in that area is very clear that any new buildings are to comply with the LGVCO design standards.
Yeah, and I agree. They should have followed the code. I was just wanted to understand how it fit in there and if it would stick out as an issue. But is also in the architectural or the code enforcement, if we go and we deny this, I know obviously one you mentioned bringing down the building. Are there other steps that would be taken? Can we get into some of the detail of that?
So if you deny the entire application, then code enforcement would proceed, which would require removal of the entire structure. If the site design variances are approved and the architectural design variances are denied, then an option is that the applicants could come back with building design for a building that meets or better meets the requirements of the zone of the overlay in that same location. So they at least wouldn't have to go back through the variance to the build to line minimum building width and height at the building line, build to line. So at least those variances would be taken care of and that location for the structure would be approved. So they could come back with another design for a new building or for a major modification potentially to this building at that location. But one thing I do also have to mention is that this structure did not receive a building permit when it was constructed. It would need to meet building codes. And so I'm not sure the extent to which meeting those building codes would also require potentially tearing down the structure and building anew or severely modifying the existing structure. So not only to meet the architectural standards, but also to meet building code requirements. So I'm not sure if that fully answered your question, but they could potentially come back with a new design in that same location.
Okay, great. Thank you, Ellen.
Ellen, so if we point blank said it could stay, you would still have to go through the building permit process, building permit process.
That is correct. It would still need to comply with building code, get a retroactive building permit, and make sure it's meeting all of those codes now. And if that is the case, then we would ask for final building plans for review and approval of staff that are the same and substantially similar to the site plan building plans that we've already received with this application. We would also require a notice of development restrictions to formalize that unified site, as I mentioned at the beginning. We would also, prior to final building inspection or final occupancy, we would require that the applicants complete all of the siding, roofing, and externally visible portions of the structure and paint the siding as proposed in one of the exhibits in the materials board provided to us. And we would require a final inspection by planning staff to ensure that all of those conditions were met prior to final occupancy or final inspection.
Okay, great.
Mr. Chair, I just wanted to emphasize, I think the applicant has three choices. One is to submit a compliant design. Well, one is tonight to show that that this design better accomplishes the purpose, goals, and objectives of the base district and the overlay. I mean, it's to meet the criteria the staff found was not met. That's one option to them. The second option is to have a compliant design per the code, or really the third option might be to put forth a different design that, although not compliant, they would seek a variance, not this design, but an alternative design that again better meets the purposes, goals, and objectives. So if they could come forth, I suppose, with a different design that's not compliant and then show how it meets the criteria. The other thing I would say is that, of course, the code enforcement process options are not really before the commission. The question is, does this design meet the variance criteria?
Okay, thank you. Any other questions for Ellen? Okay.
I do.
Oh, sorry, Kirk.
I was curious if the materials used are, the roofing and the wall materials are prohibited. How can we then say what they built is, theoretically, if we decide, how can we give them a variance for materials that are prohibited in the overlay? I don't quite understand how we could do that.
Well, if you find that the variance criterion, general design variance criterion A2, that this alternative design would better accomplish the purposes, goals, or objectives of the Lake Grove Village Center overlay, and that the Lake Grove Village Center design variance standards criterion B, that there aren't alternative designs that would be better or available or practicable, then that is how you could find that it meets those criteria. But those are the two criteria that we identified that are not met in the applicant's materials.
Well, I understand the design issue, but I thought in the report it said that the overlay has prohibited materials, and then the structure was built with prohibited materials. I'm trying to get my head around. I can understand given a variance between 8 feet and 10 feet, but I'm having difficulty saying what is done is prohibited, and that's okay for the DRC to say, notwithstanding that a listed prohibited materials have been utilized. I guess I'm trying to figure that one out.
So that again goes back to the criteria for issuing a variance or for approving a variance. So if you find that the criterion of the variance are met by these prohibited materials, then you could approve the variance.
I guess I would say it's a heavy lift. You have to see some sort of extraordinary design using prohibited materials in order to better meet the goals, objectives, and purposes of the district. It is a heavy lift. That's up to the applicant to make that argument. Staff has it.
Thanks, Attorney Boone. So,
Okay.
That's all I have, Chairman.
Any other questions? Then we would move on to the applicant. I might ask before we do that, Kat, has anybody signed up to speak?
No one has signed up to speak.
Okay, thank you. Victor, are you representing the applicant?
Victor's on mute.
You're on mute?
Yes, I am.
And Mr. Lopez, before you get started, this is Evan Boone. I'll be keeping time. You have 20 minutes, and I'll just verbally interrupt when you have 1 minute left.
Okay, thank you.
Victor, you have the floor.
Unfortunately, we lost connection for about the last 6 minutes, so I just rejoined, so I missed some of what was said. Although I picked up on the gist of some of the questions and issues. It is apparent, and we've stepped into this, obviously in a code enforcement situation, asked to retroactively come up with potential designs that would meet the criteria. That being said, I'm sorry?
Go ahead.
Well, we're getting some major interference here.
You're a little feedbacky, but we can understand you.
Okay. Basically, the standpoint that we came up with was we were trying to depict the minimization and minimalization of the impact that the building had, but we also understand that the materials that have been used don't meet the standards. I think that the Shabazians were of the mindset that they would have loved for the building to be accepted as is, but they are also willing and able to modify the structure to meet the architectural style as much as possible, or to meet a certain type of criteria for that, and also to change out siding and roofing as necessary to meet that without tearing the entire structure down. In representing the spirit of what they've talked to me about and what we've been dealing with, they're not digging their heels into the sand by any means. They're just looking for an expeditious route It's not going to be an enormous financial burden to modify the building as necessary to make it acceptable. And I think that's probably the easiest explanation I can offer the board.
Okay, thank you. Does anybody have a question for Victor?
I do.
Mark?
What are you proposing that you will do? I understand the posture, but I guess the question I have is, for tonight's purposes, is that I would have thought that there would have been a proposal on the table.
I can try to address that right now, pending internet connection issues. I'm trying to see if I can get to a screen that I could share with the board, but I'm not able to access at this moment. Wait, let me see here. Basically, we did submit a series of design perspectives to the city. And I'm trying to get back in through a VPN connection right now, if you guys can bear with me for a moment. Modification of the roof would probably be, as before I got disconnected earlier, I heard one of the members asking about how much modification versus tearing the structure down, or what would it take. I think that we could get closer, if not compliant, by doing something substantial with the roof, which sounds pretty big, but on a 16 by 16-foot building, it's not the end of the world if that has to be the route that we have to go to get compliance, to change the architectural style. The roof really is one of the biggest impacts to that style. Siding could also be something that we could modify a little bit easier, and take away the hardy plank, which is one of the prohibited materials, and then also find a different roofing material that would be more compliant and not a direct violation as the composition roofing is right now. My VPN's trying to connect, but unfortunately we're not getting in just yet to try and pull up a set of plans for you. Again, the initial variance that we turned in was with the hope that the style that was already there would be accepted, basically because of financial burden to take it apart. But that being said, there's been enough investment in this building, and it has a dedicated purpose for their employees, that they would very much like to keep the building and, within reason, do what's necessary to make it comply architecturally.
Any other questions? Kirk?
Mr. Lopes, I'm trying to figure out, what is your role? Did you build the structure originally, or did you walk into the scenario, or what?
We walked in, we did not build this, no. We walked into it after code enforcement had been involved. The Shabazians did not have a strong understanding of how much, for lack of a better description, red tape was going to be involved in coming up with a compliant structure. So it started out as a site plan to do for them to turn into the city, and then it evolved into design or drawing as-built as to what was already there, and then it evolved into coming up with some alternative designs that they would like to submit, and that evolved into writing a 12-page narrative variance application on their behalf, and culminated in tonight, speaking for IDA tonight.
So who built the structure?
The Shabazians had it built. I don't know. They had the various contractors assist with building it on site.
So another general contractor built this and then used subs to build this, or theoretically 18 by 12 foot building. Is that
I don't know that there was a general and I can't attest to that. I don't know if there's a general contractor involved. from what I understand, and this is just my interpretation, the Shavazians kind of generaled it themselves. I know that there was a miscommunication in that they did make what I would refer to as a limited good faith attempt to find out if they needed a permit. They simply forgot to mention that they were located where they were located and that it was a commercial enterprise. And they went with a typical question that they asked somebody. I don't know whether it was the city of Lake Oswego or somebody they asked to say, do we need a permit for a structure under 200 square feet? And somebody said no, which can apply in certain residential applications and certain conditions. It does not apply, obviously, in this particular situation. So they moved forward on their own without consulting anybody at that point, feeling they were in the right and they could build this small structure for their employees to take breaks in. And then, of course, code enforcement got involved, and here we are tonight.
So I guess, did you say that they asked somebody about this? I mean, I'll be honest with you, I've never heard of a 200 square foot exception. I mean, I've been doing this a long time. I know I can't build a deck without getting a permit. So I'm trying to figure out.
Most jurisdictions have a variation between 200 and 250 square feet of what would be considered a shed. As long as you don't put electrical and you don't put plumbing and you don't do a lot of other things to it, you can build a storage shed as long as it meets setbacks in a residential application in your yard without a permit. There are, of course, some jurisdictions that may take exception to that, but it is a pretty common practice throughout the entire Portland, Southwest Washington metro area that you can do that without a permit. The minute you put electrical in it, you need a permit. The minute you put plumbing in it, you need a permit. There are caveats to that entire process, but there was some ignorance involved and some probably general belief that what sounded good and sounded right was going to be enough to fly, and it didn't fly. So
Commissioner Smith, I can confirm that for residential structures in Lake Oswego that are less than 200 square feet and less than 10 feet in height, that don't have any electrical or plumbing associated with, they do not require a permit. So he is correct on that. However, in a commercial application, someone could do a shed that's 120 square feet or less and not require a permit. But in this case, so even though it's in sort of that residential zone, it's because it's a commercial structure and it exceeds 120 square feet, it does require a building permit.
And also because it's intended for human occupancy of the employees.
That too.
Right.
So
Thank you.
Does this structure have electrical and plumbing, or?
It has electrical, but I don't believe there's any plumbing. No, there's no plumbing in it, just electrical.
Okay.
Any other questions? Okay. I think, Evan, since we don't have anybody, has anybody signed up to testify since we had the presentation?
Still nobody has signed up to testify.
Okay, so I believe our next step would be for Evan to take over the floor.
Yeah. Jessica, did you want to talk about applicants' options before I go into this? Okay.
I would. Thank you very much. So I do want to point out to Mr. Lopez that he does have the option in order to kind of salvage this application if you feel that the DRC will be headed towards the staff recommendation of the denial of the design variances but approval of the site variances. What you could do is ask for a continuance for the application in order to modify it to comply with the criteria, either the full criteria of LGVCO standards or the design variances. And that could be to either what we call a date certain, where you could say, I would like to continue it until next month, the second meeting of next month, or in November or whatever. Or you could leave it open and I think either way, we would have to renotice the application, but it would still allow you to continue and move forward with the current application. Whereas if it got denied, your other choice would be to either go with the denial and reapply, which means doing this all over again, or you could appeal it to the city council. So I just wanted you to be aware of what your options are this evening.
Okay, thank you.
That
Is that something
it
that I
would
need
include-
to identify right now?
Yes, so you would need to request the continuance prior to entering deliberations, the close of the public hearing. But one thing that I at least would specifically be kind of looking for would be the proposal or the plans of how you would propose to modify the structure to better meet the code. That is something that you could submit if you do request this continuance. But if you don't
Absolutely.
request the continuance, okay.
Yeah. And so just so I'm clear on this, with the staff recommendations on the site approval versus the architectural variance denial, is that all tied together, or do we have the ability to have, I guess I'm not familiar with a partial decision, like the site portion is going to be okay as long as we propose and modify the architectural side of it, or are they tied together in a continuance again?
Well, the site variances, the staff has recommended approval of that, and unless something substantially changed with the existing site, I think we would continue recommending approval. I mean, it's just not practical on that site given the other buildings that are already located there. So if you were to submit a revised design that complied, I think our continued recommendation would be approval of the site variances. So there would be no need to finalize that decision. That would just kind of remain as part of the application, and you would just be addressing the design portion of it.
But to be clear, this application is for 6 variances, and if you want a continuance, you can't say, I want a continuance for 3 of them, but please move forward on the decision of the other 3.
Right.
You can't bifurcate it. So you could take your approval on the site variances, and then we're done, and then you can file an application, a separate application all over again for the design variances, or submit a compliant design.
I think we'll move for the continuance, and we'll provide an alternate architectural style and materials.
Very good. Are you going to do that on a date certain?
I think we can do a date certain if we do have the ability to look at the first week of November. That would give us plenty of time to put together the entire package.
Jessica?
We do need to have some time for staff to evaluate it and do a revised report. And we also have to provide 20 days notice prior to that hearing, because you would be submitting new plans. So we do have to renotice the application. So you just need to keep that in mind. So we would need to have that material at least at the very least 20 days before the hearing, but actually we would like to have a little bit more because staff needs to review and be able to give you feedback. So there's not going to be any consequence to you if you don't pick a date certain. So you can leave it more open-ended, although Evan, Mr. Boone, can you confirm we don't want to just leave this open-ended forever and ever, right? I mean, usually the DRC would say, you know, you need to submit new materials before, I don't know, at least 3 months from now. And if you do it a month from now, that's okay, but you'd have at least 3 months. Is that what we've done in the past, Mr. Boone?
Yes.
If we, I mean, as long as we have approximately 30 days to work on the alternatives with IDA on it, we could then get it to you with your 20 days that's required. So I'm okay with kind of just coming up with whatever date that comes out to in early November or late October, whatever that would be.
So why don't we just say submit by January 1?
I think that gives us plenty of time.
Yeah.
Okay, I will throw out there that there is the 120-day state mandated date would be November 7th.
Well, if the applicant requesting continuance, that extends the 120 by the amount of the continuance.
Okay.
So that 120 is stayed until we get back to this point, because we're ready to make a decision. So if you want a continuance, We're going to be staying the 120 until the next hearing date.
Okay.
So if that's
So
the
we
applicant's
have-
request,
Yes,
we
please.
have meetings scheduled for November 2nd and November 16th in November. Those are the two available dates. Again, I would say that as a general rule, we would want to get the materials at least a month in advance for staff to be able to, actually, it would be nice for you to kind of work with staff ahead of that, and we can kind of help guide you along the way, and certainly getting those materials at least 30 days before that hearing date so that we have time to mail out the notice, prepare the staff report, et cetera.
I think that's very reasonable, and we can certainly get something to you by October 16th-ish. No problem.
Okay, so the November 16th date is what you would like to request
Yeah,
a
that would
continuance
be
to?
great.
Okay.
Okay. So I think that's all we need to do, right, Evan?
yeah, so if he's actually requesting a date certain of November 16, then the motion would be to continue the public hearing to permit the applicant to submit additional material to the November 16 meeting.
Would somebody like to make a motion? Randy,
Yes, so moved.
second, can I second?
So seconded.
Thank you. Kat, do we need to take a vote?
Here.
Yes.
Paulson,
Yes.
Berardi,
Yes.
Smith,
Yes.
Zeiland,
Yes.
Arthur.
Yes.
Thank you. The continuance has been granted. So that is kind of the end of the meeting tonight, unless we have any schedule review or management update from Jessica.
Yeah, so Councilor Kohlhoff already updated you on the council's decision on the appeal for the Shorenstein application last night. As you heard, they did uphold the DRC's decision 5-2. So she already said that, but that was one of the items I wanted to cover with you. And then secondly is the next meeting will be on September, pardon me, I think it's September 21st is our next scheduled meeting. And we do have a tree appeal that was rescheduled for that date. That's the only item we have on the agenda for the 21st. And then other than this item on November 16th, I don't have any upcoming DRC meetings scheduled, but I'll certainly keep you informed if anything else is scheduled.
Okay, great.
That's it.
I may have a conflict on the 21st, so David, if you're around. Okay. All right, if we have no other business, we are adjourned.
Thank you.
Thank you.
Real.
Thanks, guys.